Hello, everyone, again. It is lovely to have my friend and esteemed colleague, Julieta Lemaitre, with us from New York, although she is from Colombia. And Julieta is, we are going to interview Julieta. It's becoming a Bergen tradition to have an interview with a woman judge. And when we started this, Julieta was not a judge, but now she is. So now she qualifies for the interview. And it's very exciting because it's rare to have someone who has been an academic all of her life and then makes the jump to the judiciary. So I find that angle particularly precious. Julieta, as I said, is an academic. She was a professor in Universidad de los Andes, a law professor. She has a degree from Los Andes and a PhD from Harvard and a master's in interdisciplinary studies from NYU. And I think it must have been about 3 years ago, right, Julieta, when you decided, was that 3 or 4? Already 4? It started 4, but you probably...
Hi, Ruth. Hi, Siri. Thank you so much for inviting me. And hello, everybody. I know that I have friends who are sitting there and I can't see them, but hello.
They are here. So Julieta decided to embark in an adventure, I would say, 3 years ago when she applied for a judgeship at Colombia's Jurisdicción Especial para la Paz. So this was a special jurisdiction or judiciary. She will tell us more about, set up in the framework of the peace accord and Colombia's transition. And more concretely, she sits at the Sala de Reconocimiento. So this is a chamber for the recognition of truth, responsibility, and the determination of facts and conduct. We will hear more about this in a minute. For now, welcome, Julieta. And maybe, Julieta, if you can just start by telling those in the audience who haven't been closely following up the Colombian process, what is this special jurisdiction, what is the JEP, and what is the task of the chamber you're sitting in?
Yes, of course. Hi, Ruth. Thank you. And it's really odd. I wish I was there and not talking to my computer, but I'm really happy to be with you guys. So the JEP was included in the peace accords with the FARC, Fuerzas Armadas Revolucionarias de Colombia, which is one of the longest standing guerrillas in the world. It started in 1965. Actually, it was a peasant guerrilla originally closely affiliated with the Communist Party. And then after the end of the Cold War, it took off on its own. It actually got to be a pretty remarkable army, about 20,000 men in arms and a wider group of civilians supporting the war on their side, and engaged in different moments in peace negotiations with the Colombian government until finally in 2016, the peace accords were signed. And part of the agreement, which is an extensive and detailed agreement, is the creation of a special jurisdiction to try them for war crimes and crimes against humanity. But pursuant to the agreement, the special jurisdiction was meant to try all crimes against humanity and war crimes committed during that very long war, including those committed by the Colombian armed forces, and including civilians who collaborated in the war effort and also participated in the commission of these crimes. So that was the basic set out for the jurisdiction. The selection process was, like you mentioned, sui generis, which basically anyone who was a lawyer and had a certain experience in human rights, and this included academia, could sign up and to be selected by a panel of both Colombian and international experts. And so at the end, 38 of us were selected. And I know you'll love this. Half of us are women. So parity from the outset. And the first president was a woman. It's when you see a picture of the court of the special jurisdiction, it's remarkable because it's not just half of us are women, but also for the first time in a high court, and I'll say even in the judiciary, there's a proportional representation of ethnic minorities. And so there's 8 of us that come from an ethnic minority background. 4 are Afro-Colombian and 4 are belong to indigenous peoples. Of those who belong to indigenous peoples were also authorities in their own traditions. So it's a really interesting court, and we're meant to try war crimes and crimes against humanity with the mandate that if whoever recognizes responsibility for these crimes goes straight to sentencing. So that's basically what my panel does. There's 6 of us. We're in the lower chambers. We build the initial cases, which are meant to be, in Spanish, we call them macrocasos. I have no translation for that, but they're meant to try thousands of crimes. And
mega cases.
Yeah. And to try those most responsible for the crimes. That's the mandate. Mm-hmm. So we build the cases, we identify those most responsible, and we ask them to accept the charges. We charge them. If they accept the charges, they'll go straight to sentencing. If they don't, then they'll have a trial, regular trial. So we're sort of a pre-trial chamber. There's nothing. We're also investigative judges in the continental legal tradition. And that's about the closest analogy I can give you. It's an odd judiciary. So on the one hand, we're investigative judges, and the closest thing to us would be the amnesty chambers in the South African Truth Commission.
So is the idea that if the charged people accept the charges, they will go straight away to sentencing and get a reduced sentence as opposed to what would be the other sentence? And if they don't accept the charges, then there's actually a procedure that is opened with all the, but potentially with higher sentences? Is that how the whole
mechanism? If they don't accept the charges, they'll have jail time. And the whole procedure is an adversarial procedure. It's more familiar to people because it's a lot more like the regular justice system. But if they accept the charges, the mandate is to follow what's called the dialogic procedure, which means there's a lot of listening involved. It's got some elements of mediation. And there's a mandate of restorative justice. So there's a lot of mediation, like in restorative justice. There's a lot of listening to victims. There's a lot of we've been creating judicial spaces for this encounter between victims and perpetrators. It's really interesting, and in many ways an experiment. And the sentencing will be mostly some sort of community service and some sort of restriction of freedom of movement, but not incarceration.
Mm-hmm. And is there also a dimension of reparations for victims in this whole scheme?
So as you know, Colombia has been involved in reparations for victims for a while. And it's like an archaeology of legal reform. So the previous system, the 2011 victims law, is still good law. And there's this whole scheme for administrative reparations. And that is parallel to what we're doing. So that is still on. Mm-hmm. And then in terms of judiciary reparations, the law says that we cannot give in indemnización, which is an individual reparation. Compensation. But we can, in this community service or whatever activities, they are meant to have a restorative dimension.
Mhm.
So the clearest example of what can be mandated, for example, is to work in demining, which has a restorative dimension for communities affected by landmines that were set up by this same guerrilla. That's really complicated in terms of the humanitarian dimension of demining, but that's just one of the possibilities. So whatever they work on it is meant to have some link to the harms, but to communal harms.
Julieta, you mentioned the peace accord, which is probably has come to be known as the most feminist peace accord in the world's history. Maybe you can illuminate us a little bit about, what are the features that have made this peace accord so, well received by the feminist community, but also maybe beyond the composition, which is parity, and also ethnic inclusive, which is already, the picture would probably not look like a court if for general people. Beyond those features, are there any other features that have permeated in the modus operandi beyond the composition itself? So two questions that are hopefully interlinked.
So the inclusion of gender in the peace accords has been documented by several academics already, and it's super interesting because it was very contentious issues at the point of the referendum. And sadly, it might have led to the loss of the referendum on the peace accords. As you probably all know, the peace accords were put up to a popular vote and they lost. They lost by a very small margin. And in this margin, the fake news, the way gender was included in the peace accords was represented as the inclusion sometimes of mandatory homosexuality and all these diversions of a gender perspective that are usual actually in resistance against equality. So while this was a gross misrepresentation of the actual accords, the accords did have both the initial accords and then the final accords, because this was something that was edited out partially after the loss of the referendum. So for example, the language in the first version was much more directed towards gender inclusion, and the final agreement is much more directed towards the inclusion of women. So because of this whole homosexual panic that ensued. So that part was interesting, and still it has a strong gender mandate, which was reinforced by the Constitutional Court. And then when the HEP started, it had a woman president. So I think it's the first time that a woman has been so visible as a president of a high court, because of the strong opposition to the institutions that came out of the peace accord. At a certain point, just focused on a tremendous resistance to the court. And this was also focused on her, on Patricia Linares, as an individual, and resistance to her and personal attacks that would probably, at least in my opinion, not have been as intense and as virulent if she had been a man. And just by if she had simply been a man, because her career was, she's a mainstream human rights lawyer, she's been an academic, so she was not a controversial person in herself, except that she was a woman. As soon as the court elected a male president, the situation was visibly changed. So there's that part. I think that part of the resistance, probably unconscious, has been to the fact of having women be visibly in power. And so there's parity, there's a gender commission that was formed right as soon as the court was set up. And so because of my background, I had this feeling like I have to go to the Gender Commission, I have to be part of it, but I've been doing this for decades. So I showed up for the Gender Commission, and then everybody was there. It was the first time in my life that it was not just three of us, you know, like, okay, let's talk about the usual stuff. Everybody was there. There were men there. Everybody wanted to be in the Gender Commission. So I said, okay, this is the time where I realize the world has changed and I can relax. And very deliberately, I did not participate in the Gender Commission, for example. And when the time to elect a president came, I supported a young woman, because I think it's time also for a generational renewal of feminism.
Yes.
And it's been really interesting to watch, because I have been a very interested observer of the Gender Commission. And they have very intensely advocated for the prosecution of sexual harassment. Even so, we've had a judge who was already, a male judge, was already denounced for sex harassment, and his case is pending before Congress. There was a security, the person in charge of security was fired very publicly because of sex harassment. So the institution is taking very seriously the sex harassment complaints internally, which is a first. There's also a lot of interest, internal interest in having there be like the place of work to express the fact that there's gender parity.
Mm-hmm.
Zero tolerance, really, to any form of sex harassment. And it's interesting because it brings up all these issues of class and race that are there once you start turning your aspirations into institutions in feminism. So that's been fascinating to watch. Also, we've become a venue where different feminist groups are interested in lobbying, and as is usual when feminists have power, all the internal divisions immediately emerge. And that's also, it's been just fascinating to see it happen.
Julieta, there's so many interesting dimensions to having women on the bench and having a bench that is inclusive and diverse and gender parity. And of course, I think what you're pointing is to a scenario in which we overcome the threshold mentality and we really transform institutions rather than making sure that a few women are there, usually doing double, triple shifts, whatever. So it is very rewarding to hear that is being the case. Let us maybe focus a little bit on the substance of the work that you do and discuss jointly maybe some of the input of, or some of the effects of having, you as a woman, but so many of your colleagues engaged in this work and the difference then that makes. And I'm thinking of these macro mega cases. And as far as I could learn, it's actually very interesting because you gather the information from a multiple set of sources. You take on whatever information is already at the judiciary linked to prior cases. You also take NGO reports, but you also take victims' testimonies and a very wide set of victims. And I'm assuming that allows you to do something that we feminists have been pushing for when it comes to methodological insights about how to approach the law and judging in particular, which is, embracing a much more contextualized approach to the law. Is this the case? Both, and has it been facilitated, both by the mandate and the way you work, but also by the fact that you have women sitting on the bench?
So I'll talk about the case that I built, which is so we it was a bit random we decided which were the first cases that we could build. And I was assigned the kidnapping case against the FARC by my panel. I wasn't too keen on it, but that's what I got. So one thing that I was interested in personally with of my feminist background, and so there's like things that I don't talk about frequently. I hired all women. So I sort of like an inverse affirmative action, some sort of affirmative action. I don't know, it turned out that way. So my team was mostly composed by women. Some men are on board, but they're a minority. And it turns out that this whole issue of peace and peace building, which is what we're doing, disproportionately attracts women. And we in my office, mi despacho, what would be the, I don't know the exact
office, yes.
In my office, the group, there's a poem that we all like by Wisława Szymborska. It's called The End and the Beginning. You can look it up. And it's about how after every war, someone has to clean up. And that's part of the work that we're doing when we're gathering testimonies of what happened, comparing it to judicial investigations, listening to the perpetrators and their versions. There's a lot of, so one of the things that I've been interested in is the normalization of what would have been 30 or 40 years ago, a woman's way of working. And without ever saying, and now I think this might have been a mistake. I should have said that I was doing this. But at the same time, I just wanted it to be normal, to not have to say it. So there's been a lot of we have been listening to women, but with special concern in order to balance the traditional not listening to women and taking seriously what women have said and their own experience of kidnappings. And as a result of listening carefully, in the charges, we included a section on the harms of kidnapping, the harms not just to the individuals, but to communities and to families. We've treated the family members of the kidnapped victims as victims in the same right as the persons who were kidnapped. Mostly the direct victims of kidnappings were men, but it's been women who had to take up all the responsibilities, negotiate ransom, find the money, look for the bodies. So even the term of looking for the disappeared is often said in the female, buscadoras, because this has been women's labor. So and the pain and the responsibility and even the mental health effects of this huge anxiety and fear and trauma of kidnapping, we try to show how it involved everybody and not just the people who were captive, which were mostly men. And in terms of women who were captive, we signaled the gender nature of the indignities. For example, something that was very usual, it actually, we found it at almost every situation, was that captives were observed while they defecated or urinated, because there was a fear that they would escape at this moment. But when the captive was a woman, the whole act had a sexual nature that we related not just to the indignity, but to cruel and unusual punishment and to sexual violence. So, and we used women's testimony to talk about this. And so we were interested in a more complex understanding of sexual violence in captivity, not just in terms of the actual sexual act, but also on the experience of being violated, for example, while being watched, while defecating. And so we did bring women's experience to the forefront in many ways. But, and to be honest, I now think that perhaps we should have, because I've spent, since we published the charges in January, quite a few scenarios where I've had to explain what we did, because at least part of the feminist movement expected an explanation in the charges that this was using a gender perspective. And so the naturalization of a gender perspective was not enough. I should have explained that this is what we were doing.
How interesting. But you're doing this now, and I'm sure you will be doing this in writing.
Yes.
And it will also be interesting to, in a context in which there is so much, backlash against gender and gender talk. I'm not sure that you were wrong. I'm not sure that, saying what you're doing is more conducive than simply doing it in a different way and normalizing it. I myself, I think, would have shared some of your, there's a trade-off to everything. Once you brand it, it's going to trigger emotional reactions. And remember, you are the ones who are, I mentioned it just a few days ago, how this anti-gender discourse was so prevalent. In fact, it tipped in a way the balance and made the referendum fail. So this is still the same people. It's still the same audience. So I am not sure that you're doing the wrong thing. Maybe you're doing the savvy thing, and you still have lots of years ahead of you as a scholar to then say, well, this is what I was doing all alone and all along. It's fascinating to hear you, and it makes me, of course, want to know whether, because of course, as you know, the Colombian case is unfortunately known to have been one of the many, it's actually the norm, cases of very high incidence of violence against women and sexual violence in conflict. Are we likely to see one of these macro cases focusing specifically on sexual violence, or do you think it's much more likely to come up, by way of, showing some of the side effects of other forms of violence? What is your sense?
So one of the fascinating results of actually having most of us be women, and most of us be women who are committed to gender equality, is that debates that would otherwise be marginal are now at the center. And one of them is the debate around the relationship between the empirical research on sexual violence and the there's a cultural aspiration that when you criminalize sexual violence, when you make it visible, what you make visible is also a societal reproach that we're no longer tolerating sexual violence. And this is part of what's being made visible, and it's part of what motivates activism. It's not just, and you do feel it in the organizations that come to us. Their interest isn't so much in having individual perpetrators charged with sexual violence. Their interest is in having sexual violence be visible, be considered important. And the idea of a sexual violence case has come to gather all that energy of the aspiration of having sexual violence finally be something that's at the center of people's experience of war, and that's it's a huge harm. At the same time, there's a tension with the empirical dimension of the work that we do and the criminal charges, which is you have to have the evidence in order to charge individual perpetrators. You have to build a case with the standards of evidence that are the ordinary standards in criminal law. So there's a tension there that's also expressed in debates on whether or not there's variation in sexual violence in civil war, which is a different field, but it ends up showing up here, because if you assume there's no variation in sexual violence in civil war, meaning that all armies rape and they rape equally, then when you don't have the evidence, you can sort of assume that it's a problem with the evidence gathering process, because you assume that there's the same kind of violence, and then you just have an evidence gathering process. If you don't have the evidence, you should really look for it because it has to be there. But if you assume, and I personally do believe that, and I think that Elizabeth Wood's work is really enlightening, that there is variation in sexual violence in civil war, and that while sexual violence happens in a context that's patriarchal and heteronormative, there are particularities to the violence during a war that don't make it exactly the same continuum of the violence in private life. And I do believe that. For example, when a woman is being tortured, she will usually be raped. But this is part of the torture, at least as much as it is part of ideas about what a woman is. Men who are tortured are also frequently raped. So there's a specificity of the violence in war that is not there in civil life necessarily. So there's a lot of debates on the evidence, on the quantity of the evidence, on the quality of the evidence, and on whether or not the absence of massive evidence of sexual violence is a problem of evidence gathering, or is a variation, in the sense that, for example, as you mentioned, in the Colombian conflict, the paramilitary armies, it's been documented that they use terror as a counterinsurgency weapon. And part of terror, there's like a vocabulary of terror. It includes, for example, beheadings and the public presentation of the head severed from the body. And it includes public rapes and public tortures. The guerrillas had this to a much lesser degree, at least insofar as we have the evidence. So that's when the question arises. Is it because we're not documenting sexual violence, or is it because there was a variation? And that's sort of where we're at, documenting. So I don't think, and this has been my public position, I don't think that we can say a priori we will have a sexual violence case, because we're still documenting. And from the documentation, the context of the sexual violence must emerge. For example, if you have rapes in the context of interrogations, I personally think it would be a mistake to take the sexual violence and separate it from the context of the interrogation, because it loses meaning, both for the victim and for the perpetrator. They both understand that the sexual violence is part of the interrogation and part of the tortures. And it would be, I think it would defeat the purpose of talking about the truth of what happened, to say, no, this is a sexual violence that happened in the interrogations, and then we have the other stuff that happened in the interrogation. But you can also have, and there's a prime example in the paramilitary commanders. There was a very famous commander, Hernán Giraldo. He was known for raping young girls. He had a preference for deflowering girls through rape, and would ask to have these children brought to him. So the context of that crime is patriarchy. It's the idea that girls and women are to be raped, and that's the context of that sexual violence. And you cannot include that, and as if this was the same as stealing a cow, which he also did. You have to really make visible the gravity of this systematic deflowering of girls, as if it was his right as a commander. Mm-hmm. So I do think that sexual violence needs to be understood in the context. The context needs to be documented, and we have to take the victims seriously, to listen to them, and to be able to make sexual violence visible in the context in which it happened and where it makes sense for both the victims and the perpetrators. When you retell because this is what we do, we listen to everybody and then we, in the charges, we retell the story of what happened. And I do think that when you retell it, it has to make sense to society. And the only way it can make sense to society is if we really document what happened. So it's a very difficult mandate.
I see. I guess, you know, something in me would want to say that ideally you would want to have the double stride. I mean, one challenge is, of course, documentation. That is just a challenge because this is the criminal, you know, law standard. And this is what makes this different from other kinds of settings where you have, you know, reparations commissions, administrative channels, or truth commissions. You're still looking for evidentiary standard to meet the criminal justice threshold. And this is a challenge. Having said that, I think, you know, in our ideal mind, we would want the double strategy. We would want the sexual dimension to be flagged out in its specificity, when it's a form of torture, when it's a form of humiliation, when it's a form of intimidation, plus maybe a case which allows us to think about the connections, because I'm with you that they're not the same, but I'm probably also with you that there is a core element of power dynamics that brings them together. Otherwise, why would they reoccur in all these contexts? But let me ask you about, you said that not only women, but that you also have Afro-Colombians and indigenous peoples. Are we going to have a big case on those, on the forms of violence targeting these ethnic communities that allows that part of the conflict to, you know, kind of come to the fore and be given as much consideration as the other forms?
Yeah.
Or again, Julieta, do you think it's more conducive to have a mainstreaming approach where in every other case you flag out the differential impact on these communities? What is your view on this?
So ideally, I agree with you. Ideally, you would have both. But it has to reflect the evidence. And we need to gather the evidence where we don't have it. So in terms of ethnic peoples, the way my panel started was that we also set up cases that are much closer to the ground. So we call them the territorial cases that are closer to the ground in those regions of the country that were particularly ravaged by the war. And at least two of these regions, the victims are primarily indigenous peoples and traditional ethnic Afro-Colombians, because race in Colombia, as you know, it's both race as in Western societies, where it's more like a skin color and cultural issues, but part of urban life. And also there's a dimension that's closer to an indigenous identity in the communities that were initially formed in the 18th century and even before that by escaped slaves, where they have specific cultural traditions, some of them even specific languages, but also a particular relationship to property, to land use, to all sorts of cultural heritage. So in the second dimension of ethnic Afro-Colombians, we also have cases that focused on the harm suffered by them. But they're smaller regional cases for the moment. Mm-hmm. I imagine that if the evidence is enough to say that this happened in the whole of Colombia, then we will say it. But otherwise, we're initially focusing on these localities where ethnic minorities were particularly targeted, both by the guerrillas or by the army. And something that's been fascinating, by the way, my indigenous colleagues are taking up the mandate, is that they're leading us to take very seriously the experience of indigenous justice, which is in the Constitution, but has seldom been taken seriously by the ordinary courts. So we're having an interjudiciary dialogue with the indigenous authorities, trying to identify which cases were already tried by them and whether or not the penalties that they already imposed, which are generally community work penalties, are equivalent to the penalties that we will have, and to learn from their own tradition of these alternative sanctions that are non-carceral, and that are also in some peoples aimed at reparations. So in southeastern Colombia, there's a tradition that understands criminality as the unbalancing of societal harmony. And the whole language of a crime is said as an unbalancing of harmony. And the whole idea of justice is how to rebalance societal harmony and what will again create harmony in the community. And that is a worldview that I think that we can learn from. So it's also a constant learning process.
Fascinating, Julieta, really. Let me maybe turn to the law. You know, you have been writing about the law, the meanings of the law. Has your view on the law changed from when you were a professor writing about the law to now that you're a judge applying the law? So what would you say?
I've been thinking a lot more than I used to on the ethics of being a judge and the materiality of judging. What does it mean to judge? What does it mean to say this is the law? You are a criminal. What you did was a crime against humanity. And to have another human being in front of you and to say this, and then to have the victim there and to say you suffered. And the whole ritual of the law has become more and more physical. So when I go into court, everybody stands up. I am wearing a black robe. And everybody's warned before I walk in that they must not talk unless I allow them to talk. They cannot leave the chamber if I don't let them leave the chamber. And there's a policeman there, and I have correctional powers. So hypothetically, if somebody's disruptive, I could send them to spend the night in a jail. And that's just, it still blows my mind but it's like I become this figure of authority where it's not a personal authority like it would be in academia, where you walk into a room and your authority is based on what you know and who you are. And that doesn't matter who I am or what I know. I walk in, I am the judge, which means I am state. I am a facet of the state, the one that says what justice is. And this has become a lot more materially significant because of the rituality of what I do and because of the way people relate to me. So the respect that they show me is not a respect. They don't respect me as Julieta Lemaitre. They're respecting the state and the law, which I embody. So they call me Your Honor. And there's like this very concrete thing that I find strangely significant, which is you have these old commanders, they ordered so many crimes and they're aging, which means that they need to go to the bathroom very frequently. So in the depositions, they start squirming and then they ask for permission to go to the bathroom. And I find that just, I don't know, it's the whole, it's like the actual submission to the state and to the idea of justice. And when at the end of every hearing, when I generally, if there's no continuation, but it's the end of that hearing. I try to wrap up what happened. And I notice everybody is really paying attention, like my students never did, I'll say that, to the way I'm wrapping it up, because there's like a closure that comes from the manifestation of the state's authority saying, this is what happened. Mm-hmm. So now I'm really interested in that possibility of justice and the ethics.
Fascinating, Julieta, and we should probably think of harsher disciplinary powers at universities, like a small prison in the bottom ground. Julieta, you are talking about you embodying the law, embodying justice, being the state. One of your last writings, I think it's your last book, has as a title, El Estado siempre llega tarde. The state always arrives late. I believe you wrote that out of your reflections from the work you did with displaced populations in Colombia. Now that you are the state, let me ask you, ¿llega siempre tarde el Estado? Does the state always arrive late?
Yes, definitely in a war. So there's there are many variations on the idea that there is no law in war, only the will of the prince. There's a Latin saying that now slips my mind on how there is no law in war, only the will of the prince. And in that sense, the state, as we understand it, as the law, was never there. It wasn't there to protect victims. Even when these are crimes of state, it was not the state that was there in the sense of justice or what we would want the state to be. So once we're imparting justice, it's always after the fact. And the fact is also that when these things were happened, we were not there. So now it's got an additional dimension. When I wrote that book, it ended up being, so it was based actually on work we did with Christine Sandvik, and a group of graduate students. We spent 3 years studying displaced women and their organizations, and we published a series of articles, and also we wrote materials with NGOs. It was really exciting and satisfying. And then when that was over, there were a lot of stories that I heard on the field that kind of haunted me, because I thought that they said something about Colombia that I did not fully understand. I always had the sense that there was something that I wasn't getting. And that phrase was one of them. So it was a public official, somebody who worked in the victims unit, who says that it's really hard to use, she called it la camiseta del Estado, making an analogy with the soccer team's t-shirts, and saying wearing the t-shirt of the state, so the uniform of the state. And one of the things she said, because you are always late. When you get there, people have they have buried the dead, they have figured out how to get on with their lives, and then you arrive like the state and saying, oh, I have something for you. But you were never there with them when these things happened. So she said that was part of what made the work so hard. And so that phrase came out of that interview. And it was one of those moments where it just haunted me until I could write it down. But I was trying to understand what happened during the war.
Julieta, I want to leave some room for the audience to see whether they have questions for you. I'm going to start by people who are here physically with us. Is there any pressing question? I know that Siri has one. Siri.
So thanks a lot, Julieta.
It'd be great if I could see the audience. I can't.
So I can.
I don't.
Yes, you can.
Can
I think you can put on. Do you have
the cameras? This is being recorded and live streamed. So let me see whether we can get that. Can you see Siri now?
So thank you so much.
I can't hear Siri or see her. Oh,
Can
okay.
you hear her? No.
Okay. So I will try.
Come here.
Do this one now.
Yes. Now. Yes.
So thank you so much. This was really, really interesting and a lot of food for thought. So and you've touched on a lot of the issues that I was curious about, but maybe say a little bit more about how being. I mean, you're not only a legal academic, but you're a social legal scholar. Who for many years have sort of studied dynamics around the law and how the law is being used and so on. Do you think that makes you a different judge? Do you think that influences the way you exercise judging, but also sort of the broader way in which you sort of influence the bench as well, where you're sitting? Do you think it makes?
Yeah, so it's been very demanding work. And I don't know if this would apply generally to all judges. If I were a different type of judge and not engaged in these issues of the Civil War, what would it be like? So I don't think I can, what I'm about to say applies to all forms of judging, but it certainly applies to the work that we're doing at the Special Jurisdiction for Peace. It's incredibly demanding work. And like all demanding work, it really calls on every fiber of your body. I thought it would be, when I began, I thought it would be easier to have compartments. Like, this is my academic life. This is what I'm doing now. And actually, I've been keeping ethnographic journals, and part of my mind saying, oh, this is a book I'm going to write someday about this. But it just gets harder and harder to do because the word is so demanding and so difficult that you have to use, or I've had to use, and I think my colleagues as well, everything that I know, everything that I'm capable of. I'm not saving anything. So this means that part of what I've been doing has been doing what I learned as a social legal scholar. And it's part of the kind of judge that I am, because it's what I have. And I have to put everything that I have, everything that I can do in this work. So a lot of and it's been actually quite useful in part of what we have to do. And I think that it's been my contribution to the jurisdiction, because I was also a teacher. So I've been training younger people to approach the research sort of like a research project in the university. So I have the people who work with me draw up research plans, like this is a doctoral project, and a lot of what I've asked for them comes from what I learned to do both as a sociolegal researcher, but also, funnily enough, since I'm working with teams of people as a thesis director, or as somebody who worked with students doing research, because we are doing research. So a lot of the skills, a lot of the knowledge I've had has been applied to our work. And initially I thought, oh, we need to hire somebody who knows how to do this, because I'm just a social legal scholar. I've never done like this type of research. And then I realized actually nobody has, because the whole framework was so different. And the mandate of building these macro cases was so new. So it's taken up everything. I'm giving this endeavor everything that I have, everything that I learned. And necessarily it means that I have approached it as a social legal scholar. I don't think this is the way it must be approached. My colleagues approach it with everything that they have, and what they're bringing to the table is different. So each one of us is just leaving it all in the field. And my colleague, who's an indigenous authority, is using everything she knows of indigenous justice. And this is just the way we're trying to make this work.
We have a question from Margaret, online question. Let me summarize the question for you. And maybe connected. And Margaret is particularly concerned with sexual violence in children, and with the ways in which families are sometimes complicit in what happens to the children. So to make it more, context relevant, she's asking how you go about that. Let me ask you more generally in relation to this question about, children's and the experience of war of children, and the complexity of family and parental members and relatives in this context. How are you dealing with that?
So I'll say that in that sense, our complexity doesn't come so much from the real life complexity of what Margaret is pointing out to. But criminal law makes it easier in the sense that children cannot consent. And so any sexual contact with children is per se a crime. There is no consent by definition. And anyone who participates in this is complicit in the crime. But we are also charged by law only with prosecuting the combatants. So unlike a real life situation where this would be a lot more complex for a prosecutor, who would then have to examine whether or not the family members were accomplices or themselves victims, we are charged solely with the combatant's responsibility, and any sexual access with an underage, a person who does not have the capacity to consent, is a crime. Mm-hmm. The situation in sexual violence, I'll say that gets more complex, is sexual violence among combatants that who are adults or who have the capacity to consent. That is a very charged and complicated situation, and that there's no clear solution.
I agree.
But with children, it's just a lot. It's hard to say this because it's terrible. And in real life situations, it's a lot more complicated. But in terms of our mandate, it's not as complicated.
Is there any other question from the audience? If not, I will maybe close with one final question. I was watching your interview when you got hired as a judge for this jurisdiction. The interview is available on YouTube in Spanish. And it struck me that when asked, what was your motivation behind applying for this, you said that that you were fascinated by, and it reflects in a way what you have already said, by the trust, the newly gained trust of citizens in law and in the state institutions, and that you wanted to be part of the project that supports and gives reasons to citizens to, indeed have trust in the law in the state institutions. Now, women have had many good reasons not to have trust in either in the law and in state institutions, given the high levels of impunity that they have had to face vis-a-vis almost every form of neglect and abuse they have experienced. Is there anything from your experience as a woman, as a judge, as a scholar, that you could now, share with us in terms of what do you think would need to change more fundamentally for women to reaffirm their trust in state institutions and in the law?
So this also comes from writing that book, El Estado Siempre Llega Tarde, that last book. It was also, when I wrote it, it was an ethical reflection in the sense that there's this basic question in ethics: what does the life of others mean to me? So it's a deep ethical problem. When you approach other people, what do they mean to you, to your life? How do they? What's your relationship to them? And when we were doing all this work with displaced women, it's just there's over 1 million families who lost their livelihood and fled the war. And I wondered in a personal level, what did it mean to me and to people like me who had not lived the war? And there is no way to have a good life and to respond ethically to that without the state. So individual action will not cut it, or charity, or helping one. You can't help one group of people. There's too many of them. So my conclusion was that the only correct decision, or the only ethical possibility, was to be the state, to be part of the state, and to be part of something larger that could respond to people's needs, that could respond, so that you would then respond not as an individual, but that you would respond collectively as the state. And in that sense, I thought that the only thing to do was to be part of the state, at least for a period, and to respond actively, because otherwise it's impossible to live a full good life, because of the face of other people, of their life always meaning something for you. It's really difficult to live in a country as unequal as Colombia, as war-torn as Colombia, and to have a happy, full life, and then just ignore the plight of those who have suffered so much and who have lost everything. It's impossible. But then it's also impossible to pretend to answer it as an individual, because what they need is just much more than even all your resources, all your life, all your possibilities. It's just impossible. So my conclusion was that the only ethical thing to do was public service, at least for a period of one's life. I don't
So
know.
even if the state arrives too late, we still need the state more than ever. Thank you so much, Julieta. This was wonderful. I will let you have a last word. I saw you were gesturing to that, please.
No. I agree. I don't know if the result will be ethical, but at least the effort, I think, is, hopefully.
And we thank you for that. Thank you, Julieta.